Hello and good evening, everyone. Welcome to LiveLaw Academy. Today's discussion is related to satire, your freedom of speech and expression, and how do we navigate the boundaries for the same. Now, this becomes relevant for your judiciary examination as this will be revolving around the idea of Article 19, the protection that is granted or the freedom that is enshrined under the Article 19, and that is how your constitution being one of the subject, you can refer to this. We also understand that what are the reasonable restrictions that are to be imposed. In addition to that, there are certain provisions from IPC that have been quoted in this case. Not just that, you also try to understand the scope of the High Court for Section 482 of CRPC. That is the inherent power of the High Court. Not just the discussion in this case, but also a lot of judgments that have been quoted, a lot of precedents that have been quoted in this case by for the explanation of Section 482's power. That is also something that we'll understand. We will understand how do we perceive a reasonable person, which is applicable when we talk about civil law, when we talk about criminal law, how this reasonable person has to be perceived, what should be the extent of granting freedom, and very, very specific to the special law, wherein we will be understanding that how different provision related to the STSC Act are being imposed here, have been invoked here, and whether the quashing of the FIR is right or not in the given factual situation. In addition to this, you also understand about satire, whether satire should be granted protection in the provision of Article 19, whether that will be rightful to do or not. Okay, so these are different aspects which are asked in different laws in your judiciary examination relating and revolving around this case of Dinesh, Borkar and another versus state of Karnataka. Very recently now, this has been decided, and we have to see that what are the facts of this case. So before we get into the discussion of the provision, let's try to understand that what are the facts around which the case is revolving and how the law will be applied in the same situation. So we have certain set of students and faculty members who are also the petitioners in this case, who have reached to the High Court by Section 482, invoking the power of Section 482, requesting the High Court to quash FIR. The FIR has been filed on the basis of claiming that they have committed certain offenses. I will take you to those offenses also, but these offenses are generating from a skit that has been played by the students of a particular college. The students, by virtue of their skit, were trying to suggest an idea, or were rather making a satire on the people of lower caste, due to which there were multiple cases that were filed against the authorities as well as the students of the college, and therefore the entire prosecution before it begins has now been challenged by the petitioners here in the given case. Okay, so these are the brief facts as mentioned here. We also, when we will be talking about a certain provision, we have to see whether it has been performed in public or not. So that is why I've highlighted certain points here. There are students, the caste of rather neither the accused nor the party who is aggrieved here has been mentioned or has been disclosed. Okay, so that becomes a relevant factor, that the caste of the faculty members or of the students who were taking part in the skit has not been disclosed. The skit was performed as the fest that takes place annually every year in the convention center, and this was done to showcase their acting skill. So if we have to read out the intention of the party, and all these will become relevant as we move on in our discussion. We are understanding that there is no disclosure of the caste, and the party who is complaining here is actually does not really belong to the scheduled caste or the scheduled tribe. All right, so the complainant does not belong to ST/SC caste, and the parties, the accused, their caste have not been disclosed here. Secondly, their intention, if we try to see, shows that it was to showcase their acting skills, and this was a satire that they have tried to make rather than actually intending to hurt or humiliate people from scheduled caste or scheduled tribe. So this has been the factual matrix. There are certain alleged offenses that have been claimed here, which is section 153A of IPC, 149 to 95A of IPC, which basically talks about hurting the religious sentiments of certain people, and also engaging. And also when we talk about section 149, so all these people have collectively been held responsible for these offenses. And we also have special law mentioned over here, the ST/SC Act, wherein three provisions, that is section 3(1), clause R, S, and V. These are different offenses which have been claimed here. I will take you to through each of these offenses one by one. Now, here the petitioner is claiming. Now, when we are talking about whether quashing of FIR has to be done in this case, the petitioner is alleging and saying that there is no intention to harm or humiliate. This was merely done for sheer entertainment, for participation in the fest. There is no material that they have tried to prove to show that their intention was to intimidate. And also it is not it has not been disclosed in the FIR that the members of ST/SC community have felt hurt by this. And also they have mentioned that this is in the nature of satire, which is absolutely protected under Article 19 of the Constitution. So these are different claims made by the petitioner seeking and invoking the inherent jurisdiction of the court with respect to the protection that they expect to be granted to them. Now, when we talk about this in depth, we also try to understand that what is the nature of power that is mentioned under 482? What are the ambit of these offenses which are so mentioned here? Okay, so let's get into that discussion. When we talk about 153A, we are promoting enmity between different groups on the ground of religion, race, place of birth, resident language, and which is prejudicial to the maintenance of harmony. So there are cases that have been mentioned in this judgment, wherein the court has highlighted and a certain precedent and said that there must be different groups that must be highlighted. So let's say in a given case, when we have Kashmiri Muslims on one side and we have armed force, Indian Army personals on the other, in that case, can we really allege that the offense under 153A has been committed? So the court said that no, there must be different groups on the ground of religion, race, place of birth, that must be so there. Secondly, 295A, section 295A of IPC talks about deliberate and malicious acts which are intended to outrage the religious feeling. So again, very important that the act must have been promoted or must have happened by an intention to outrage the religious feeling or with malice, which again has not been proved so far by the complaint in the case. These are the two provisions. Then we also try to understand section 21 RS and V of the ST/SC Act. Let me just take you through the act also. Let's go to the law and try to understand this. So when we see the PDF of this act, let me take you to section 3 directly. Section 3 very clearly requires certain factors which must be disclosed. First requirement is whoever not being a member of ST/SC. So the mandate here is that firstly the accused should be somebody who does not belong to this caste. So if you recall, I told you very clearly that it has not been disclosed the caste has not been disclosed either of the faculty members or of the students. Then what are the offenses that we are trying to claim? First is under R, that is intentionally insults or intimidates with the intent to humiliate a member of ST/SC caste in any place within public view. So it is very much important that you disclose that the intention was to humiliate. If it is merely for entertainment, then definitely the intention would be missing. Next is abuses any member of the scheduled caste or scheduled tribe by caste name in any place within public view. Again, the other essential is that the abuse has been made based on the caste name. If merely it has been done during the play, during the skit, then in that situation, the idea of it being an abuse gets negated. And the last one, highlighting that by words, so this is related to a deceased person, if by words either written or spoken or by any other means disrespects any late person held in high esteem by member of STSCs. So this has been invoked in another recent judgment wherein one person says that you are taking away the name and the high esteem that B.R. Ambedkar has gained. So this will fall under in this particular ground wherein we say that if you are by your word written or spoken, if you are disrespecting, demeaning a person of high esteem who is no more there, who belong to the caste of scheduled caste or scheduled tribe. So these are certain provisions that have been highlighted in this case, by which the party is claiming, by which the complaint has been filed, claiming that this is in violation of these sections under the STSC Act. The petitioner is trying to highlight and convince the court how this is not being done. So firstly, the petitioner is doing so on the basis of absence of intention, that the intention was never there. Secondly, the freedom that is granted under Article 90, also talking and also disclosing that there are no facts and the accused is required to be, not to be required to be not from this caste of ST/SC, which is also something that has not been disclosed here. Okay, so all these requirements have not been highlighted, and that is why the petition requests that the FIR must be quashed. Okay, so as we understand, Article 19(1)(a) provides us one of the most basic freedom, that is with respect to our speech and expression. And court has shown concern here and have quoted various precedent by which the court says that we see that there is highly or there is growing intolerance of people towards the views of others, which actually is leading into depreciation of various arts. So it is very important that freedom must be granted to people for them to express their opinion, from them to express their views. It can be in any form. It can be word spoken, written, it can be any art form, and it can be by way of a skit also. And therefore such sensitive and intolerance towards the views of another should be condemned. We must ensure that the freedom granted under Article 19(a) stands protected. But at the same time, we also understand that we have 19(2), which grants reasonable restriction. And if there is an intention to humiliate a person of a scheduled caste or of a scheduled tribe, that definitely will fall under the ground of 19(2), and will also be, the protection so granted under STSC Act will also be invoked. So that is one thing that the court has acknowledged in the given judgment. Then the court have very specifically spoken at great length about the scope and power under Section 482 of CRPC. So when we talk about inherent power of the court, very clearly it is to secure the ends of justice. So it is threefold. One, we say that to give effect to an order under the code, then it can be to prevent abuse of the process of the code and to secure end of justice. So this point also has been highlighted, abuse of the process of code. The court has said that if in a given situation you do not disclose the relevant ingredient of any offense, or the relevant essential of any particular section, and yet you go ahead and file a complaint or FIR against a person, will it not be abuse of the process of the court? Yes. So in the present petition also, if you see, the relevant ingredients have not been fulfilled, and despite of that you go and you file FIR or complaint. In that situation, it is definitely abuse of process of the court, and here quashing of FIR should be allowed by invoking or exercising the inherent jurisdiction, the power of inherent jurisdiction that the court holds. Also, to secure the end of justice, if the court feels, if the court realizes that it has to step into, in any case, it has to step in and try to protect the right of its citizens, definitely that also will be allowed. Now, this is based on ex debito justitiae, which means that there must be real and substantial justice that has to be done. So thus again, just a second, I'll again share my screen. Thus again asserting and thus again emphasizing on how justice and imparting of justice is an requirement, is a prerequisite for us to for us to provide remedy to the parties. Okay. Now, these are different highlights that I've picked from this judgment as well as multiple other cases that have been quoted, which talks about the scope of the inherent powers. Okay. If my screen was not visible, let me just take you again that I have referred to section 3, wherein I talk about the requirements mentioned for proving any of the offenses under section 3. Okay, so firstly, that the person who's accused must not be of the same scheduled caste or scheduled tribe. Then we spoke about R, S, and V, wherein we understand that the intention to humiliate must be there. Secondly, if you are abusing a person by calling out their caste name, that also will lead into the offense. And the third one, that if in case of a deceased person, that also can be one of the offenses if you are disrespecting that late person who belongs to the scheduled caste or scheduled tribe. Okay. Now, what should be the scope of the power given under section 482 of CRPC? So I have mentioned a few key points here. Firstly, because it is a very wide power, if you see the words also as mentioned here, it is a very wide power granted to the court, but granted for protection of rights of its citizens, right? Therefore, we allow this wide power, but at the same time, we put an embargo that it must be used cautiously, keeping in mind that it is for the promotion and it is for the protection of justice. Secondly, it is to be exercised when the court realizes that it has to condemn the abuse of process of law. I quoted one example right now to you. If the essential of ingredients are not getting fulfilled, despite of that, you go to the court and you file FIR or complaint, then in that situation, power of 482 can be invoked. Secondly, the court acknowledges the fact of the likelihood. So there are so many civil cases which turns into criminal cases out of the frustration of the litigating parties. Specifically talking about the tenant disputes, we see that the frustrated landlord may go and file a criminal case also against the tenant. So we have to keep that in mind while entertaining a petition of quashing the FIR under section 482 of CRPC. Then the idea of the section is to secure ends of justice. And what could be the possible grounds? So one is if the prima facie case from the evidences or arguments, we are not able to materialize the case. As I was saying, the ingredients are missing, or the allegations appear to be absurd or are inherently improbable. In that situation also, the court can invoke the power mentioned under 482. And the last one, when it does not disclose the commission of a cognizable offense. So these evidences and the arguments do not really disclose a cognizable offense, that can also be another forum for us to for the High Court to exercise this jurisdiction. So this has been highlighted by the court for the court to further decide why they are actually quashing the FIR in the present case. Okay, so they have entertained, they have elaborated on whether the court has the inherent power to actually quash the FIR in the present case. Yes, because of the abuse of power that is very much visible here in the given factual matrix of the given case. Okay. Then the court also answers on the basis of absence of intention to humiliate. The court has said that when we refer to the provision, the intention to humiliate must be present, and when we refer to the facts of the case, we find that it was rather for a satire or a satirical skit that was being played here, and there was no intention to humiliate any person of any caste. Secondly, the absence of the fact that the accused are also from the scheduled caste or scheduled tribe, no assertion has been done. Then the court goes into the explanation of satire. As to what is satire, it is a literary genre. The court has spoken at great length about it, that how a satire is considered to be a different class wherein we allow somebody to ridicule or to ironically represent the topical issues. So there are so many issues that are so existent in a situation. Your intention, as long as it is only to inform people, to entertain people by way of ridiculing or by way of any irony, it will be granted protection under article 19. But the minute it leaves the the ambit of protection, it can be, one ground can be, if the satire targets the marginalized. Now in that situation, you are actually strengthening the view or strengthening the prejudice of certain people. So in that situation, definitely the protection will not be granted. So it will be seen from case to case basis. It will be seen what are your intention right now in the present context, when these boiling situations have been there with regards to the Allahabadia case. This case, we understand that it has to be assessed as to whether the satire was actually made with an intention to bring information, to bring entertainment to the people, or was it actually to marginalize or to seclude certain class of people, and accordingly the protection will be granted or not protected under this class. Then the court, when talking about satire, when talking about the accused here, also talks about the aggrieved. The court says that we acknowledge growing intolerance. As I told you, we have to see that whether how do we see a reasonable prudent person. It should not be a person who is intolerant. It should not be a person who is very sensitive towards the opinion of other, and rather it should be a person who, as mentioned in this particular case, who is the man on the top of Clapham omnibus. So this is a phrase used, in torts cases, torts related cases also, wherein we say that how do we assess a reasonable person. So in English cases, this was a phrase which was used traditionally also. The man on the top of the Clapham omnibus is considered to be a reasonable person, an intelligent person who understands the impact and accordingly decides. So it should not be an overly sensitive person, a person with egg skull, and rather it should be a person on the Clapham omnibus. Okay, there are various explanation of using this idiom or this phrase, as to Clapham was a place which was very much secluded, not that much travel to, and therefore somebody who is going there, we will say that he's a reasonable prudent person who's taken that decision. Then it was also that people who are sitting on the top of the Clapham omnibus, so people who have taken that rational decision. So there are various interpretation of this, but the idea of this idiom is to acknowledge that a reasonable prudent person will be the one who is weighing and balancing the outcome, the effect, and then accordingly is an intelligent person who is making that call. Okay, so that has been discussed here. And also the fact, yes, and also the fact that when we talk about section 153, I already gave you this example. This is the name of the precedent that has been quoted, wherein the court is highlighting and the court is asserting that you will have to highlight that there are two religious groups, there are two groups which are divided to different group, and then accordingly you can invoke section 153A, which also is missing in the present case. Therefore, keeping in mind all these facts holistically, the court has highlighted and the court has taken the following decision. So now I will take you to the copy of the judgment for you to understand with me that how the court in this given case has given the following order. Therefore, all these further proceedings that have been taken pursuant to these cases will are concerned are hereby quashed. So when you are addressing a question which has come for quashing of FIR, I have told you as to what is the scope of the power that is available to the High Court. In what all situations it can be invoked, you have to see whether it is, whether if the quashing of FIR does not take place, it will be violative or it will be against the interest of the parties here. The court will have to say whether the law requires it to interfere, it to intervene in the furtherance of justice and accordingly take this decision. If it will not do so, it will materialize into abuse of power. So these are the basic ingredients that have been discussed in this case. Also, the factors like we have to see the societal reality and accordingly take the call. So the court also has to see whether it is mere, what are the facts, what is the relationship that the parties share, whether it is merely a very sensitive person who is coming to the court and complaining of the same, or rather it is based on the actual belief, and all the after recognizing and after acknowledging that all the important ingredients of those provisions have been fulfilled. So this is the the idea of this case. I'll just now take you through the judgment. Firstly, the court speaks and highlights about the intention that has to be read, that has to be highlighted, and therefore the court says that if the intention is absent, if you're not able to prove the intention to the court, in that situation the court should not be entertaining these cases. Secondly, merely because a person who has died belonged to the scheduled caste or the scheduled tribe will not be sufficient. You will have to prove that the statement has been made because the person belonged to a scheduled caste or scheduled tribe. So that should be the basis of filing the complaint or of filing the FIR, rather than merely going otherwise and saying that the person has died and because he was ST/ST or belonging to that caste or tribe, he should he should not have been hurt. Rather, intention to humiliate has to be highlighted. All right. The next explanation is with regards to the proving of satire. As I already told you, the court acknowledges that in the given society, in the developing society, everybody should, facilitate understanding. Everybody should allow communication and expressing their views and points. And therefore, if, unless and until the satire has been made with a wrongful intention, it should not be prohibited and it should not be restrained. All right, so this is more or less the discussion that we had to cover in today's class. We will again be seeing you with another relevant judgment. If you have any doubt, you can drop your doubts in the comment section. If you have any feedback, you want to cover us any other case, you can let us know about that as well. Thank you so much.